Back in the 30s, and actually all the way back to 1850, we elected all of our judges here in the state of Missouri, including Supreme Court judges. Over a period of time, politicians figured out that they could basically buy judges. The most successful person to do that was a guy named Tom Pendergast, who operated a political machine out of Kansas City.
They would literally buy votes, where some of the bosses would pay somebody to go vote a certain way.
If Pendergast wanted you on the Supreme Court, you could get elected.
He tried to pack the court with appointees of his political persuasions. The people of Missouri did not want that.
And so this merit selection was thought to be a better way of doing it.
A group of people got together actually right here at the Tiger Hotel in Columbia, Missouri, in December of 1937 to create what was called the Administration for the Institute of Justice.
About every prominent lawyer in the state at the time rose up, fought back, and took this plan as a way to return the courts to the people so that it wasn't in the hands of the politicians like Pendergast.
A man named Kenneth Teasdale, who was a prominent St. Louis lawyer, got a number of people involved.
There were 80 or 90 people, all told, who came here to find a way to improve judicial selection.
These people were all Democrats and Republicans. It was a wonderful thing. They worked together.
They saw the need to be proactive and make sure that our court system is always of the highest quality and sound. And the Missouri Plan is certainly that.
People campaigned without any financial interest in it whatsoever, up and down the state, and got it adopted by a majority of the people in 1940.
It was a proposal that was put forth by a number of people on a national level. It became known as the Missouri Plan because we were the first to do it.
And it was very, very well accepted.
And there have been a number of attacks on it over the years, but it has stayed, it has survived, and it has served us very well.
It's based on merit, it's based on qualifications.
All the appellate judges and judges in the metropolitan area primarily are appointed by the governor. Now the governor only gets 3 names. Those 3 people are chosen by a commission before the governor gets to pick. This commission is called, at least at the appellate level, it's called the Appellate Judicial Commission. There's 7 people on that commission.
3 individuals from different parts of the state that are appointed by the governor. 3 lawyers elected by the lawyers of the different parts of the state.
And the 7th person on the nominating commission is the Chief Justice.
When there's a vacancy on the Court of Appeals or the state Supreme Court, it's announced, it's publicized. Lawyers may apply for the position. There's quite a complex application that they have to fill out.
You might get 20 or 30 or 40 people applying for the position. All those names go through the Appellate Judicial Commission. The Appellate Judicial Commission reduces that pool of applicants down to 3. Those names are sent to the governor, and the governor has 60 days to choose from those 3 people.
The theory being the group has screened all those who would not be appropriate, and the governor can only make a good choice.
But it doesn't stop there. After a certain period of time, this candidate who's been selected by the judge is also vetted again by the voters of Missouri.
That judge will be in office for a full year, and then at the next general election, the judge sits for retention. The judge's name goes on the ballot, and the question on the ballot is, should this judge be retained? The voters of this state get to decide whether or not that judge should be kept in office or should be thrown out of office.
It's really highly desirable. You run on your record rather than running against somebody else.
The plan has worked so well, we have had very few judges removed by retention, but that power is always in the hands of the people.
So it's a great balance of qualifications and still that active participation by voters.
The Missouri Bar is now trying to get to the voters and does a really good, solid evaluation of the people who are up for retention.
That spans from whether the judge does his or her work in a timely fashion, to the depth of the judge's analysis, to the treatment of lawyers and people who appear before the court. And I think that those efforts to educate the public have made the retention elections even more viable.
Nobody gets to vote against the incumbent congressman who may not have an opponent, but you do get a chance to vote against the incumbent judge. And the fact that those incumbent judges are, for the most part, retained speaks well for our system.
I've seen other states move to the Missouri approach. I've also seen other states persist in electing their judges, which is, in my opinion, a far inferior way to select judges.
Generally in states, it costs as much to run for the Supreme Court sometimes as it costs to run for governor. Millions of dollars. From 1990 until 2000, approximately $83 million was spent for judicial elections. From 2000 to 2010, that number more than doubled to $206 million to influence who would be selected as judges. That kind of money is spent for influence, not good government.
And it's very hard to have confidence in the judicial system when you know that the judges sitting on the bench are beholden to thousands of dollars of campaign contributions.
We've seen that problem express itself in Illinois. We've seen it express itself in West Virginia, where judges who received significant contributions then ruled on cases that affected the people who made the contributions to them.
To a business, it's most important that everyone is on a level playing field, that my business hasn't contributed more to that judge's campaign than a small business when we go to court.
Well, one of the things that has always struck me about election of judges is, can you make a campaign promise to behave a certain way or to rule a certain way in cases?
Well, it would be impossible to get a fair hearing before a judge who'd already made up his mind or her mind before anyone ever stepped into the courtroom.
Folks can go to the ballot box and they can elect their senators and representatives, they can elect their governors. I mean, that's where the partisanship should be. There's no room for partisanship in the judiciary.
What we have with the nonpartisan court plan in Missouri is superior to the federal model because it involves much less politics.
The thing about the Missouri system is that the governor is much more constrained in who he can appoint than the President of the United States is.
The governor has to make his or her choices on the basis of the three names that the governor is given.
Well, a lifetime term is a very nice thing for the judge. It takes the judge out from the people, away from the people. The one advantage the Missouri plan has over the federal plan is that judges must stand for retention.
So Missouri's plan, in some respects, has advantages over what's worked pretty well in the federal system for more than 200 years.
I think a diverse perspective of different kinds of people with different backgrounds is important, not only for perception, but also for the work that the courts do.
And I think that's what's good about the Missouri nonpartisan court plan. We're getting judges from all sectors. It instills confidence in the citizens of Missouri to know that there are Hispanic judges, there are black judges, women judges, a cross-section of judges.
The Missouri plan, as it's called, or the nonpartisan court plan, in one form or another, has now been adopted in more than half of the states.
We were the ones that started it, and it has been copied. It's been copied in 30-some states in various forms.
It was a transformative decision that Missouri voters made in 1940 in adopting a merit-based judicial selection system. And it changed government in the United States in significant ways, because now we have a judicial selection system that promotes confidence and promotes integrity and promotes impartiality in the judiciary.
What you want the judge thinking about is justice and the welfare of the people of Missouri. You don't want the judge thinking about anything else, like where he's getting his next contribution from or how it is going to impact him in the polls.
This is about making decisions based on the law, not based on politics or any other factor. And that's where these high-quality judges we want to attract need to come from, and not from a political party that has an agenda.
I'm a staunch supporter of the plan. It's not a panacea. It's not a cure-all, but it is so far superior to any other program that I'm familiar with in the United States.
My experience is that the plan works extremely well for the people of Missouri. It would be a terrible shame to lose one of the things where Missouri was historically and remains a national leader for integrity, for fairness, and for justice.